Hi, and welcome to another DPO advice from Steve. Today we're going to be talking about the safeguarding exemptions for sharing data. This is England law, and I'll mostly be talking about the situation in London where the majority of our health, social care, and education customers are based. So, what's safeguarding? Safeguarding is defined as protecting a person's health, well-being, and human rights. Obviously, it's a very important area for all of us because when it goes wrong, it can be catastrophic. It used to be a bit more difficult to share data in this area legally, but we're fortunate it was a big focus when the Data Protection Act 2018 was being written, and since that's become law, it's become much easier. In the Data Protection Act 2018, safeguarding is defined as a substantial public interest. How it defines it is to protect children and individuals at risk. It's Schedule 1, Part 2, Paragraph 18. Children as a category is fairly obvious. If you're under 18, you're a child. But how do you define an individual at risk? Well, this is stated in the Act. The person must have needs for care and support, be experienced or at risk of neglect or harm, and that covers physical, mental, and emotional harm, and as a result of their needs, be unable to protect themselves against the neglect or harms. So, a person with severe mobility issues who's being neglected and care is being refused by family members would be an example of this category. There's a separate paragraph, 19 in the schedule, covering economic well-being. That's restricted to health data, but it's used sometimes when we have matters such as exploitation of persons with learning difficulties or dementia. Exploiting someone with learning difficulty by taking over their home and using it for criminal purposes, so-called cuckooing, is an example here, as a romance or friendship scams to gain assets from the elderly, which is sadly common. For these kinds of safeguarding issues, we can share without the consent and in fact over the objections of the data subject and without informing them to relevant bodies, so long as they've got an agreed set of procedures governing the data use. For London, we've got a London-wide data sharing agreement which includes all the requirements that I helped author, and that sets down the processes for doing this in the public sector. Note that there's also an exemption where it's a life or death situation. That's called a vital interest. The vital interest of the person is allowed to be taken into account, and we can always share data to ensure that life is preserved. Another safeguarding area where some organisations actually have duties to share is the prevent duty. This came in from the Counter-Terrorism Security Act 2015 and applies to local government, schools, including academy trusts, NHS trusts, and a number of other public sector organisations. It doesn't apply to GP practices, but bear in mind that some of these issues are under the safeguarding duty, so it may be covered under there. The prevent duty basically relates to radicalisation and engagement in terrorist activities. The idea is to try and help individuals de-radicalise or disengage from such activities. This commonly involves information sharing, and it's one of the few cases where there's an actual duty to share with the police rather than a moral imperative. In summary, we can and should share safeguarding data of children and vulnerable individuals for their protection, and there's a very good, clear legal basis for doing so. As always, if you've got specific questions, feel free to contact me if you're a customer. None of our public sector contracts have usage charges. We're free at the point of use. If you're not a customer and would like to become one, please email us at sales@excathedral.solutions. And thanks for viewing, and I'll see you soon.